Hi, my name is Carl Pearson. I'm a New York attorney and a graduate of Harvard Law School, and I represent homeowners and small businesses throughout the United States in foreclosure defense litigation, including quiet title actions and wrongful foreclosure actions, and this is done customarily to make the mortgage more affordable with a loan modification agreement as the hopeful end result, including any principal reduction. This video 110H, entitled A Warning About Bankruptcy, is the 8th in a series of 12 related videos. These 12 videos are being prepared for viewing in sequence from A to L and provide an up-to-date look at defending foreclosures. So here's a preliminary discussion. Let me warn you from the start. Don't file for bankruptcy unless you really know what you are doing, even if your bankruptcy lawyer tells you to file. You have some things that should be considered and discussed with that attorney before you file. I'm going to talk about some of these things in this video that you should discuss with that lawyer if you are thinking about filing for bankruptcy. Also, let me tell you now that I am not a bankruptcy lawyer. It is a very tricky field in which any practitioner has a lot of things to know, especially when it comes to Chapter 11 reorganizations and reorganizations of single asset real estate organizations called SARE, S-A-R-E, under the Bankruptcy Act, and when using bankruptcy to avoid foreclosure or a foreclosure sale. Now that I've given you my warnings, I have certain things which you need to know. One, the first is that in bankruptcy you and your lawyer are treated as near criminals, to be watched and frustrated as much as possible, with no such treatment given to the banks, their lawyers, and others who are looking to take over your assets. Two, your lawyer generally will not be able to get paid while you are in bankruptcy, so that your lawyer will be motivated by the bankruptcy system to do as little as possible because he's not getting paid any additional money, and to get rid of the bankruptcy as quickly as possible. Now, when I say that motivated, I'm saying that because of the way things work, this is an inevitable consideration and tendency that when you don't get paid, you just don't work as much. Now, there are many lawyers that have put in far beyond what they were paid to do, and therefore you never know. And there are many lawyers in bankruptcy courts, bankruptcy lawyers, that are doing a phenomenal job under these very trying circumstances. So I'm only giving you a precautionary note here. Three, during this period, if your lawyer makes any request for payment of fees, it will be scrutinized by the bank, the bank's lawyer, the judge's law clerk, and the U.S. attorney, who's a federal official paid by the U.S. government, who will make objections to your attorney's fee application, which will cause your attorney not to get paid for a significant part of his work, while at the same time the bank's attorneys will be putting in hours that are not disclosed, doing things that are not disclosed, getting huge legal fees in hourly rates that are obscene, like $800 to $1,000 an hour in many cases, and without any knowledge or supervision by the bankruptcy court at all. Just imagine that disparity between the competing forces here. Four, because of this system of bearing down hard on the bankrupt and his attorney, the bankruptcy courts have been converted since the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. Remember, these statutes are named to be exactly the reverse of what they say they are, so don't forget that. And signed into law by President Bush II, into a court favoring banks and other creditors and shafting the bankrupt and the bankrupt's attorney. That's the way it is. Deal with it. Just know that that's the way it is right now. Five, it's not the bankruptcy court's fault. This is the statute that caused this. You are much better off going into state court to litigate your problems with the bank. Six, accordingly, do not let a threatened foreclosure occur without you first going into the state court. In judicial foreclosure states, this means that you should obtain an attorney and defend a foreclosure action on a timely basis, with an answer with counterclaims if appropriate, and in non-judicial foreclosure states such as California, you should file an action in state court against the lender and servicer in what I call a quiet title action, long before the sale would otherwise take place, alleging, if appropriate, that they don't have the right to foreclose to foreclose because they are not the holders of the note or in the chain of title, or that robo-signing was involved, or there are other defects, and if true, that you were a victim of loan modification fraud. You can look it up, and it's called dual track fraud, in which they have you applying for a loan mod at the same time that you're in the foreclosure process, but they force you into being in default before they will consider your application, and they go ahead and foreclose as you were trying to get a loan mod, where if you hadn't tried, you wouldn't have been in default and they wouldn't have a basis for foreclosing. So that's the dual track loan mod fraud that's going on. 7. In other words, seek timely protection from foreclosure in the state court system and avoid bankruptcy. 8. When you file for bankruptcy, you will not be able to challenge the validity of the bank's mortgage lien, because this requires a separate lawsuit called an adversary proceeding within the bankruptcy proceeding. And bankruptcy lawyers will not commit to undertaking such an action unless they are paid a substantial amount of money in advance of the filing for bankruptcy, such as a payment of $40,000, to ensure they have enough money to pursue the adversary proceeding and related expenses until it is completed, including any trials, appeals, and remands and retrials, and motions, and everything else. 9. If you, the bankrupt, had $40,000 in cash to pay the bankruptcy attorney, you would not be filing for bankruptcy in the first place, so that the filing of bankruptcy without any hope for any adversary proceeding to challenge the bank's lien is not a promising situation and should be avoided by using the state court system to challenge the lien of the bank. 10. In the state court system, you can file a lawsuit against the bank for an initial fee in advance ranging from about $5,000 to $10,000 approximately, and the filing of the action in service of the summons and complaint may encourage the bank to give you a reasonable loan modification agreement, including a principal reduction, which the bank would not otherwise be willing to give to you. 11. Bankruptcy litigation is very costly for what it accomplishes because of the extra proceedings needed to prevent the bankrupt from ripping off the bank and other creditors. I'm saying that in jest, I hope you gather. A quiet title action in state court is not encumbered with all these additional protections that bankruptcy court now gives to the banks. And once again, it's not the court that gives the protection, it's really the statute that forces the court to now be owned by the banks rather than to be helpful to the debtor. 12. Instead of calling the recent amendments the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005, the statute should have been called President Bush Jr.'s Campaign Gift to the Banks and Stick It to the Homeowner Act of 2005. 13. In Chapter 13 cases, there is the following practice about which you should be aware, and it may apply to some extent in other types of bankruptcies. The lender encourages the mortgage debtor to file for bankruptcy, falsely claiming that they should be able to work out the problems. The debtor's bankruptcy lawyer files and fails to investigate the bank's claim of a lien during the 90-day period for this activity, and the right of the bankrupt to challenge the bank's lien is then lost at the expiration of that 90-day period, often through a cash collateral order in which the debtor's lawyer has a debtor agree that it has no defenses against the bank's claim, and the debtor's lawyer is then paid his legal fee by the bank out of the proceeds from the debtor's property. How about that? Finally, the court orders liquidation rather than reorganization, and the debtor gets nothing. The debtor's lawyer gets paid by the bank gets the property, the bank's lawyer makes 10 or 20 times as much as the debtor's lawyer, the trustee gets paid and is satisfied that it has done everything it could do to help the bank get paid on the mortgage, and the bankruptcy court goes on to render justice in additional cases. That's the system now. 14. Finally, one last but very important warning. Never, never, never sign a so-called pre-negotiation agreement in which you will be asked to agree in advance before starting any settlement negotiations with the bank that you have no defenses at all against the bank's claims against you. If you sign this agreement, you will be signing over your property to the bank, because it encourages the bank not to reach any settlement agreement or loan modification agreement with you. take your problems into court, into state court. There is really no other good remedy if you can't make your payments on the mortgage and can't work out a suitable loan modification agreement with the bank. Go to court, otherwise you'll probably lose your property. That is, go to state court. 16. Chapter 13 filings are essentially a request for a forbearance agreement in which you wind up paying each month more than you were supposed to be paying each month to the bank under your original note. There is no principal reduction permitted in Chapter 13 unless the bank agrees, so avoid Chapter 13 if you are trying to reduce the principal amount of your mortgage. 17. Chapters 7 and 13 do have an advantage for homeowner mortgagors, which you may wish to consider. You can eliminate credit card debt and eliminate underwater second mortgages and obtain a discharge of the second mortgage lien. You also could eliminate credit card debt by not paying it and waiting for someone to sue you and then defending against the lawsuit, and you will probably be urged by the judge to settle the action, which you can often do for about 20% of the amount saved, of the amount owed. A second mortgage lien is usually eliminated in a short sale with a payment of $1,000 to $1,500 to that bank that owns the second lien. So bankruptcy is not the only way of doing things, but you probably do not want to do a short sale because you would be leaving the property if you did. You should consider including the second mortgage owner and servicer in your lawsuit as an alternative, assuming the facts justify that. 18. Once again, one last comment. I think I just said that a while ago. If you have already filed for a Chapter 13 bankruptcy and are still in bankruptcy perhaps for a total of 5 years, I'm not sure if you are allowed to file a quiet title action against the bank without obtaining bankruptcy court approval. The automatic stay is probably still effective, and I don't know if you are allowed to commence a lawsuit requiring the bank to litigate if the bank is stayed from litigating, especially if you are using money of yours which theoretically is under control of the bankruptcy court. Another issue is whether a friend or relative of yours could pay your litigation fees. Would this permit you to file the action? I don't have any answers to that, and that is something which you should have your bankruptcy lawyer find out for you. So I'm now finished with a warning about bankruptcy, and you should go on to my next video, 111-I, or it's I, Defending Foreclosure Actions, which applies to 22 states. If you have any questions, please give me a call. My telephone number in New York is 212-307-4444. I provide free consultations and represent homeowners and businesses throughout the United States as to their foreclosure problems, including the saving of properties through loan modifications and principal reductions. Of course, no guarantees ever in litigation. Remember that. My telephone number again is 212-307-4444.